Actually, I'm the co-director. Sorry, David. I'm the co-director of the UNC Center for Media Law and Policy, and my brand new co-director, David Ardia, is here. He's a new assistant professor in the law school, so give him a big hand. Before I introduce our speaker, I'd like to thank a few people who are here now and have helped to make this day possible. I want to thank Interim Dean Dulcie Strawn, who didn't ask any questions about our plans, which on First Amendment Day is a really good strategy, total denial on her part. Some of my colleagues, Deb Icott, Michael Hofjes, Andy Bechtel, Kyle York, Dan Seiler, who's in the booth, Morgan, Michael Hofjes, Ruth Walden, who's here, and student volunteers. I had a whole team of volunteers doing everything from putting up posters to handing out programs, maintaining the website. If you haven't seen the video that some of the undergraduate students made, you should. It's playing in the lobby, it's on a loop, and it's also, you can go to the First Amendment Day webpage and see it. It's on YouTube too, you can find it there. It's a pretty entertaining and interesting, I think. We received funding for today's events from Raleigh attorney Amanda Martin and her former law firm of Everett, Gaskins, Hancock, and Stevens. They practice media law and support the First Amendment and First Amendment Day. I also want to thank the Daily Tar Heel. I know there's somebody here from the Daily Tar Heel, which gave us free ad space today so we could publicize our events, and also gave us that really terrific front page. You know, it could be my favorite front page of all time, all about the First Amendment. Now, on behalf of the UNC Center for Media Law and Policy, I'm happy to welcome Mary Rose Papandrea to Carolina. Professor Papandrea is an associate professor at the Boston College School of Law. She's a graduate of Yale College and the University of Chicago Law School. She first clerked as a judge on the U.S. District Court for the Southern District of New York. Then she clerked for a judge on the U.S. Court of Appeals for the D.C. Circuit. Then she clerked for then U.S. Supreme Court Justice David Souter. And I don't even know what to say about that, except wow. So I'm impressed. Professor Papandrea then spent several years as a litigator at Williams and Connolly in Washington, D.C., where she specialized in First Amendment and media defense litigation. She went to teach at Boston College in 2004. Her teaching interests include civil procedure, constitutional law, media law, national security, and civil liberties. She's currently on leave from Boston College and living in Chapel Hill with my co-director, who is her husband. And it's First Amendment Day, I can say anything I want. No. And she's working on a book about national security and the free press. The title of Professor Papandrea's address is Students, Social Media, and the First Amendment, subjects very dear to our hearts. So, welcome to First Amendment Day at Carolina.
Thank you. Well, thank you, Dr. Packer, for that very nice introduction. I did really enjoy clerking. It was a pretty cool job. Well, today, the title of my talk is Student Social Media and the First Amendment. I could have picked a lot of different topics for today. There are so many things that are interesting involving new media and the First Amendment. For example, we could talk about what is WikiLeaks doing to our understanding of the press's right to publish classified information. We could talk about who's a journalist for purposes of the reporter's privilege. We could talk about the scope of protection for anonymous speech, particularly on websites, and whether we should revise the Communications Decency Act protections for websites that host content by others. But today we're going to focus on students. I thought, why not? You guys are all, well, maybe not all, most of you are students or your professors, which is going to be another part of my talk. I'm going to be talking about government employees, teachers, and professors in public universities. Before we could jump right into it and talk about the First Amendment. And if you've studied the First Amendment at all, and you think about what kinds of cases there have been where the court has upheld the right to speak under the First Amendment, it's full of really pretty terrible things, right? Well, at least to some people. Flag burning, for some people gets them very upset. Jerry Falwell was very upset when Hustler did a spoof ad saying that his first time was with his mother in the outhouse. He didn't like that so much. We have the famous Cohen case that protected the right to wear a jacket in public that says "fuck the draft." Sorry, I said the F word. So if we go forward, the court's most recent decisions continue to protect offensive speech. One of the most high-profile cases recently was Snyder v. Phelps that upheld the right of a religious group to say pretty awful things outside of a funeral. We had a case recently that just upheld the right to sell violent video games to kids. Bravo. And we even have a case that protects the free speech rights of corporations. So corporations have full protections, and some people find that pretty offensive. But, so we might think as a threshold issue, why are we protecting all this offensive speech? And particularly on college campuses, you often hear about the issue of why do we protect hate speech. So I have a little picture here of a picket sign. Hate speech is not free speech. And I feel very strongly that it's important to protect offensive speech and even hate speech, because censoring this speech does not solve the problem. It just puts a Band-Aid on the problem. We're much better off if we know what people think and how they feel. That way we can confront it and we can address it. And the best cure for hate speech is counterspeech. Counterspeech is the most effective weapon. I should say one thing is let them talk, because often when people are engaging in hate speech, they're saying really awful things, like in that Snyder v. Phelps case with the Phelps family saying these terrible things outside the funeral. You don't even really need to respond to what he's saying. So crazy. And then in engaging in counterspeech, you can use some of the same offensive words that the court has protected. There's a word underneath this picture. And then you can see some of the picket signs in the picture to the right. So counter speech can be some of the most effective ways of dealing with hate speech. And this is because we have in this country a very strong commitment to the marketplace of ideas. And I know this marketplace is not perfect. You probably talk about it in your classes. There's some speakers who are more powerful, have more money, like the corporations, for example. So sometimes this marketplace doesn't always work. But we have this faith that if we can have ideas compete in this marketplace, that it's going to get dirty and it's going to get nasty sometimes, but that we're going to protect the speech, and that in the end, that is how we'll figure out what the truth is. But you're like, where are you going with this? Okay, but the thing is that not everybody is getting these full protections of the First Amendment. Soldiers and prisoners, boo! No, they're not getting very strong protections. In fact, I was just reading an article in today's New York Times about how there's a soldier who wants to get a copy of a book about the Civil War, and the warden doesn't want him to have it because it has violence. Hello. So anyway, there's a lot of deference going on. This is called institutional deference. We say we're going to defer to the prisons, defer to the wardens, because they know what they need to do to keep the prisons safe. In the military, similar kind of idea. All you have to do is mention national security, and okay, we better let them do whatever they need to do. So the free speech rights of members of the military and prisoners are nowhere near as strong as members of the general public. In this select group of disfavored speakers, in addition to prisoners, in addition to members of the military, we have government employees and students. These four groups: prisoners, members of the military, government employees, and students. These are the areas where the Supreme Court says, we're going to defer. We don't have the the real competence to evaluate what these institutions need to do to function effectively. And I say government employees because the case law is developed to include all government employees, state, local, federal government officials. Today we'll be focusing on professors at public universities and teachers at public high schools and other secondary schools. So do students equal prisoners? I mean, they're all lumped together in this group where the court is saying that we're not going to give them full rights. And you may laugh at this, but actually the Supreme Court has cited cases about students and prisoners together. You know, when it's deciding one topic or another, they'll bring in cases about students when deciding about prisoners, and prisoners when they're talking about students. So it's a little disconcerting. And the same thing, do teachers equal members of the military? They soldiers, you know, fighting on the front lines for the government. So let's take a quick look at the Supreme Court and student speech rights. Some of this may be very familiar to you, so I'm going to go pretty quickly through it. Just to show you that it used to be, once upon a time, that students had very strong speech rights. And I'm going to start with the Barnett case from 1943. You see this rather scary picture, especially if you think this is during World War II with the Nazism, the salute. This is the Pledge of Allegiance case, where the court said that students, particularly in this case was Jehovah's Witnesses, did not have to say the Pledge of Allegiance when they were at school. And I love this quote: "Our schools have important, delicate, and highly discretionary functions, but none that they may not perform within the Bill of Rights." Yes, okay, next case. So, wrong way. Tinker, you probably all have heard of Tinker, or maybe this is the famous black armband case with students who were protesting the Vietnam War, and they wore these black armbands to school to symbolize their protest. And famous quote from, I mean, there are a lot of famous quotes in all of these cases. I'm just picking out one, so I don't have a screen full of quotes. It can hardly be argued that either students or their teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Yeah, so Tinker offers this very robust vision of student speech rights, like Barnett, but it builds on it. And Tinker is known as the primary case about student speech rights, sort of lays that foundation. One, student expression plays an important role in the marketplace of ideas. Remember, I was just talking about the marketplace of ideas before, and what an important role the marketplace of ideas plays in our understanding of the First Amendment. And Tinker is saying students have something to say. They have something worthwhile to say. That even when they talk to each other, that's an important part of the educational process, that communication among the students is an important part of the educational process. And they come up with this standard that schools can only punish students for their speech when it causes a material and substantial interference with schoolwork or discipline, or invades the rights of others. That last part, the court has never fleshed out exactly what invades the rights of other means. And they said, you know, it's not enough that the armbands sparked discussion. It's not enough that a teacher had to quiet down the class because everyone was talking about the armbands. It's not enough that the school officials had to devote some of their day to dealing with the armband controversy. That does not count as a substantial disruption. Instead, it was important to recognize that students have something to say, even if they're saying it at school, even if it's off topic. You know, the lecture, there was no assignment that I know of in that case where the students were discussing the Vietnam War in class. But that school is an important place for students to discuss these ideas, and students have something to say. Do you like this? I thought this was fun. Since Tinker, rapidly diminishing student speech rights. Things are going all downhill. That's why I use that little icon. One, Bethel Be Fraser case. it held that students could not use obscene, profane, or lewd speech at school. This case arose in the context where a student was giving a little speech for one of his classmates who was running for elected office in student government, and he used sexually suggestive language. He was punished, and the court said that the school was within its rights to punish that speech. We see huge deference to school officials, and this becomes a theme. We're going to defer to what the school has to say, and if they think it's necessary to restrict that kind of speech in school in order to further the educational mission, we are going to defer to them. They emphasize the importance of teaching civility to the students over this robust idea of messy marketplace of ideas. Instead, the important thing that's going on in school is not that students are learning through practice of how to communicate with each other, but instead it's all about the schools teaching the students how to be respectful citizens in civil debate, which isn't really a bad thing, but if it comes at the cost of eliminating the free flow of discussion, it could be detrimental. And overall, just limits significantly the rights of the students in school. Next case, you guys probably know the Kohlheimer case. This involves school newspapers. It said that the schools have the authority to restrict speech that bears the imprimatur of the school. Basically, whatever is coming out under the school's name is reflecting badly upon the school, then the school can censor it. In this case, they cut out articles on teen pregnancy and divorce from the school paper. Deference again, we see this deference. Oh, schools, we are not worthy. We resolve complicated patent cases and antitrust cases and all sorts of crazy cases that no one understands. But when it comes to school, even though we all went to school for many, many, many years, we cannot possibly figure out what schools should be required to do, should be able to do. And they have this very deferential standard. As long as the school has a legitimate reason for wanting to restrict the speech, that's going to be fine. And then the famous bong hits for Jesus case. This just came out a few years ago where some students were holding this banner outside the Olympic torch relay outside of school. And the court says the school does not have to tolerate any speech that advocates drug use. It's not exactly clear what bong hits for Jesus means. Right? It's nonsense. The student who put up the sign said he thought it was hilarious. It was nonsense. He doesn't really know. But the school thought that it advocated drug use. So deference. So we have deference again. And they, the court made clear this is a limited holding. They said we're just talking about drugs. But it's really hard to cabin in this ruling from a constitutional point of view. First, we see the court adopting a subject matter restriction, content restriction on what the students can say. Drugs are out. Next case, I bet, no question, the court would say violent speech, even if it's not actually threatening violence, but any violent imagery because of, the Columbine history and all of that, that will be fair game. And so it really signifies a really diminished protection for student speech rights. So, what about student speech rights in the digital age? Well, this is my mathematical formula. Diminished First Amendment rights, which we already saw before, the court has never had any cases involving speech outside of school or involving technology in any way. So, but we are, even before we get to these difficult questions, we already have diminished First Amendment rights for students. Add into the mix new technology, which always scares old people. And judges, no, that's so mean. That's so mean. I'm sorry, but it's
Don't look it up.
No. But if you're not familiar with the technology, it's scary, and it could be instead of going after the problems, you go after the technology. Let's get rid of the technology, then we can get rid of the problems, and that's rarely the right answer. So the disaster, this is the train falling off the tracks with student speech rights. So we have a number of cases now that are coming up, and they're making their way up into the federal appellate courts, where students are getting punished for speech on social networks. Now I will say, most of these cases involve really juvenile, immature. I mean, it's hard to believe that I would spend all this time defending the right of these students to engage in these incredibly immature forms of speech. They're mostly fake profiles on MySpace, or it used to be MySpace, Facebook, where they pretend to be the teacher or the principal, and it's clearly not. It's so silly and juvenile. It makes the students feel better, I suppose, to engage in this kind of release. But anyway, there have been a lot of cases where students are getting punished for making fun, essentially, of their teachers and principals on using social media. And so I want to tell you about one case. Avery Doninger. Not sure any of you guys know about her, but she's a student in Connecticut. She was in student government, and she was really upset when her school canceled the musical festival Jam Fest, the Battle of the Bands, I think, sort of thing. So she was really upset about this. So she went to her blog on livejournal.com, and she wrote, "The school officials are a bunch of douchebags." Ooh. Well, the school officials got wind of this. They were not happy. So they punished her by saying, you can't run for office again. You can't be in student government again. And this was pretty clever strategy on their part to punish her in that way, because the district court's first line of reasoning in upholding the punishment of Avery Doninger for calling the school administrators this bad name was that, oh, there's no First Amendment problem here. She was just punished by being excluded from an extracurricular activity. And there's no right to engage in an extracurricular activity, so there's no First Amendment violation, period, the end. We could stop there. We won't, because we're a district court and we like to give alternative reasons for appeal to uphold for our decision. But that's a pretty scary thing, and I'm going to come to that in a little bit when we talk about social media and athletes here at the university, because we hear this argument, and with government employees as well, this idea that it's a privilege, not a right, to be a teacher. It's a privilege, not a right, to be a professor. It's a privilege, not a right, to be a football player. And so if that's the rule, then any restrictions on the freedom of speech are fine. I have a problem with that. Some of you may think that's fine. I have a big problem with that. The other reason the court gave is, well, her speech was not at school. See, this is where the issue is getting complicated with student speech rights. Does the school have authority to punish students for speech that is not occurring on school grounds? All of those cases I went through, Tinker and Hazelwood and Fraser and Morse, all were at school or during a school activity. And so the question is, well, what kind of authority does a school have to punish students for speech that is occurring off campus? And in Doninger's case, the Second Circuit, which covers New York, Connecticut, and Vermont, has come up with this test. And it's really not much of a limiting principle at all. This is the test. If the school, if it's reasonably foreseeable, that's some, legal mumbo jumbo, reasonably foreseeable to the student that the school will find out about her speech, therefore they can punish her for that speech. If she had reason to believe that the school would find out about this blog, the school could then punish her for bad words on the blog. They could punish her for if there was any disruption. They could use all of those prior cases that I mentioned, all those standards, and they could punish her at school. So that's that went up on appeal. The Second Circuit said, we're not going to decide that extracurricular escape clause for the schools. We're going to leave that aside. We don't have to reach that because we think she knew that school officials would find out about this. It was about school, and part of her blog also encouraged people to call the school to complain about the cancellation of this music festival. So therefore, she must have known that the school officials would learn about it. Therefore, the school has the power to punish her for that expression. So that leads us to this cartoon where these students are discussing that apparently the First Amendment does not protect the right to call your principal poopy pants, which is something my 3-year-old would really like to do. I'm sure he's into potty humor. But anyway, so there's a real concern. You know, I would say my biggest concern with this line of cases is that I sense that students have been making fun of their professors forever. And with this technology, it's easier for the professors and the teachers that we're talking about here to find out that this is happening. And the principals find out that this is happening, and they don't like it. And so they're going to punish it. And there really is no end. You know, back when we saw the Tinker case and the Fraser case, there was an understanding that we're talking about what authority do school officials have to punish students on school grounds. There was really not much of a question of could they restrict the rights of students off school grounds. Now, the case law was mixed. There wasn't a Supreme Court case on point, but the general consensus was developing that essentially speech that's off campus is not something that schools can punish. So, for example, if a student writes an inflammatory letter to the editor in the newspaper, you know, regular newspaper outside of the school, that's not something the school has jurisdiction to punish. If the students form a underground, this is very common, now people just have social networking sites, but if they have an underground newspaper that they're working on outside of school, even if it's about school and even if it's upsetting teachers and students, still the school had no authority to restrict the contents of that newspaper. But now with the internet, schools are thinking, well, if we're learning about it, therefore we can punish that speech. So it's not all bad news. I don't want to give you the impression that all courts around the country are taking this expansive view of schools' authority to punish speech on the internet. There was a case out of Florida that was just decided that protected the right of cheerleaders to post pictures of themselves on I remember which website. They were at a slumber party and they were licking phallic-shaped lollipops. And again, why do I spend my life defending these people? But anyway, so anyway, this is obviously not smart. Now, these pictures were not obscene. They were just suggestive. You know, and it's not really an appropriate thing. No parent or school, for that matter, wants to see students posting these kinds of pictures for everyone to see. But the district court said that you can't punish students for lewd speech online. So remember I said in that Avery Doniger case, the district court said that the school can punish students when they use bad words or lewd language online. And the lollipop case, as I call it, says, no, that's really just taking things too far. Instead, you have to have at least a substantial disruption, and there was no substantial disruption on campus from the lollipops. They also importantly said there is no free pass to punish students for their speech when the punishment involves a restriction from extracurricular activities. They said that's not right. And the Supreme Court has said, not in the context of students, but in general, that even when there isn't a right to something, that there still can be a constitutional violation if your participation is taken away because of your exercising your constitutional rights. Oh, cyberbullying. Okay, this is bad. Cyberbullying's bad, and this is probably the hardest issue in this area. I don't feel so badly for the teachers and the principals who get upset when these fake profiles go up that no one believes is real, really depicts this person. But cyberbullying can have real problems. But I also feel that it doesn't give a free pass to schools to then punish students for everything that is happening outside of school. First of all, let's keep in mind that the First Amendment does not protect true threats, and it does not protect defamation. So if anyone is actually being threatened, or if there's defamatory speech that is circulating, that is not protected. And these students can be punished who make this speech. They can be criminally punished. They can be civilly sued. There are protections. And I think what we should do instead is really focus on education and intervention. We should be educating our students on how to use social media responsibly, and we should be intervening when there are students who are suffering in the face of bullying. That is admittedly a really horrific problem for some students. And I would definitely say that we should avoid measures like banning social media in schools. Again, there seems to be a trend where authorities think, well, if we just ban the technology, we'll eliminate the problem. And as I'll talk in a moment, there are lots of good things that can come from social media. In fact, even when we're talking about cyberbullying, for example, it might be that a student feels more comfortable approaching a teacher through social media, through, say, a Facebook page or something like that. It feels less scary to approach and tell the teacher about what's happening through social media. So we need to be careful about bans like that. Okay, now what about university students? Now you may be wondering, why are you talking about high school students for all this time? We're in college, we don't care. Well, the thing is that a lot of the cases that I talked about involving high school students are used to discuss the First Amendment rights of college students. This was very strange to me when I was studying this. You know, think about the differences. Are there differences between high school students and college students? There's one huge difference. You are adults, right? You're over 18, and most high school students are not 18, although some of them are, which of course then just calls into question some of the First Amendment restrictions placed on them. But that's a pretty big thing, because those who advocate that students in high school don't have strong First Amendment rights frequently point to the fact that students in high school cannot vote. They're minors, they live under the thumbs of their parents anyway. When they go to school, they're just under the authority of the schools in loco parentis. So it doesn't really matter. But when you're talking about college, university students, you're talking about adults. So those arguments don't work. You should be more mature. You're all mature. Yes, mature. You're not as easily influenced. You don't need to be as protected from bad speech. And I think most importantly, the university is known as the quintessential marketplace of ideas. I mean, we have such a strong tradition of free expression at our universities in this country, and you know, the civil rights movement, more recent movements. I mean, this is the place. If we don't have free speech at universities, where are we going to have it? This is the place where ideas are supposed to be examined and discussed in a vigorous way. And so we have this very strong tradition. Well, it hasn't always played out this way in the courts. Some of you may have studied, there's at least there is one federal appellate court that has applied the Hazelwood standard. That's the one that involves the high school newspapers, saying that as long as there's a legitimate pedagogical concern, school officials can censor the paper. At least one circuit court, it's out in the Midwest, 7th Circuit, has said that Hazelwood, that standard that was developed in the context of high schools, also applies to the college level. So we see a little bit of a blurring here of the lines between high school and college. We also have seen students getting punished for speech on social media. So I have two examples just to put up little pictures of where they happened. So first, at NC State, there was a student who was blogging about her concerns with the veterinarian program and the horses that they were using. And the school was outraged that she would engage this kind of unprofessional kind of communications and threatened to suspend her. When someone mentioned the First Amendment to the university, they backed down. But the fact that the student was threatened to begin with for just discussing arguably an issue of public concern about what's happening in the veterinarian schools, you know, how the horses are being treated, what horses are being used, is a little scary. In the University of Louisville case, there was a nursing student who sued after she was thrown out of her nursing program for blogging about her experience as a nurse, even though she didn't mention any patients and didn't breach any confidentiality. And she sued and she won. The court said, well, you know, her blog may have been non-professional, but it wasn't unprofessional. There was no reason why the school should be intervening and preventing her from engaging in that kind of speech. So, you know, the lesson here is that it's not just the high schools that are trying to restrict what students are saying in social media. We've been seeing that the colleges often think that they can do the same thing. So this is very interesting. I call this a new twist on an old example. So I don't know how many of you are familiar with the Asians in the Library video. Can I see a show of hands? Okay, my research assistant said you guys would know about it, so that's good. But for those of you who don't, so this student had a video she put up on YouTube complaining about Asians in the library. And it was pretty offensive, using derogatory words about Asians and complaining about what they do in the library and imitating in pretty stereotypical ways of how Asians talk. And this prompted an outrage. So she posted on YouTube. It was available. Everyone saw it. And people were pretty outraged about this video. But rather than throw her out of the school or punish the school, instead, we saw social media being used as a robust forum, marketplace of ideas and action. So I don't know how many of you saw this video, this other student on the left. I wish I could play it. But he did a song. He wrote a song mocking what she said. He has a lovely voice. I urge you to listen to it. And it was so effective in just making her seem ridiculous. I mean, these things she was saying. So, you know, he was quoting what she said, and like one line he said, "Ting tong, I don't know what that means." You know, it was just mocking what she said, but using music, a very effective way of responding. There were hundreds of YouTube videos that were put up in responding to her, including a video by the chancellor of UCLA. It was using YouTube to respond, to say, we don't endorse what she said. We strongly condemn what she said. And so I thought it was a wonderful example of how social media, yes, it can spread more unfortunate messages and it can spread them more widely, but at the same time, social media can be used to rebut and be an effective form of counter-speech in the marketplace of ideas, the albeit imperfect marketplace of ideas. Okay, so college athletes and social media. So this is Marvin Austin. You guys know him. I don't know him so well, but you know, for this talk, I got to know him a little better. And what's interesting about this guy is that he was tweeting about a trip to South Beach. You all know this, so I don't have to repeat this. And this prompted, sort of launched this NCAA investigation. And then apparently another one of his teammates was tweeting about, made some homophobic remarks on Twitter. And so the coach decided the way to solve the problem about NCAA violations and homophobic behavior or beliefs among my players is to cut off their access to Twitter, because that is the way to eliminate violations of the NCAA rules, and that's the way to get our football players not to be homophobic. Okay. Well, I disagree with this approach, and I find it deeply disturbing. I went to the panel today about this social media ban, and I wanted to jump up and join in to present the view that this is a bad idea and also potentially unconstitutional. But I figured I had my moment now, so why jump up during the panel? First of all, UNC only bans Twitter, which is kind of funny. There's so many other ways that students can use social media, other ways that they can express themselves and be known to the public, and expressing a message, branding themselves and the university in a way that might be distasteful to the university. Other schools, this is a very common thing now. A lot of universities are banning their college athletes from using social media, particularly football or basketball programs. The other thing is that it's kind of strange, you know, I think one of my themes today is that social media can do bad things, but also can do really good things. And so Twitter could actually be a really useful tool for the football program to expose the message to all the followers out there who want to read what the tweets are. And so a far more effective strategy would be to educate educate these student athletes on how to use Twitter. I mean, it's hard to believe they need much education, but apparently they do, judging from what they're doing. Do they not realize that the public is seeing what they are tweeting? Do they not realize that this will affect their image? We heard at the panel today from a former player who said so many of the players are interested in professional careers. So one, they have to understand that reputation matters when they're being drafted. So that's number one. They need to learn how what they say publicly can affect their ability in the draft. Secondly, if they do get drafted, they're going to continue to have to learn how to present themselves in the public eye. So they need to learn about how to tweet effectively and how to use social media effectively. Like you guys here, I mean, UNC is so lucky you have a journalism school. You guys could be teaching them about how to use social media effectively. I also think that it's possibly unconstitutional to do this. It would be one thing to punish a student for something specifically that he said on social media. And I think that coaches do need to have some leeway to punish students who are revealing gameplays or something on social media or some other way that is directly undermining the team. But I think generally to shut off a very important way of communication is what we call in the First Amendment world overbroad. It's overbroad. It's not tailored to deal with the problem. The problem is NCAA violations. The problem is homophobic feelings. The problem is misrepresenting or not presenting the school in a good way. That's the problem. Twitter is not the problem, it's the symptom. So I feel there's, I spoke to a sports law professor. He said, unlikely a student's ever going to sue about this, so we can just have these academic discussions about whether, in fact, it's unconstitutional. But I think that there's a decent argument that it is a unconstitutional prior restraint. Okay, so I'm just going to spend a little bit of time talking about teachers and professors, and I don't know if you can read the caption here on this cartoon. It says, ironically, the government would have protected my First Amendment rights had I not been employed by the government. So, government officials, government employees, which include high school teachers in public schools and college professors at public universities, have more limited First Amendment, they have more limited First Amendment rights than maybe the average citizen. It's hard to draw this parallel because the average citizen can be fired pretty much at will by their employer, if it's a private employer, but that's another story. So the question is, how much speech should the government be allowed to repress among its employees? Is it the fact that government employee is a privilege, not a right? So therefore, you have no right to have this job. Therefore, you have no recourse if you're punished for your speech. That was originally the point of view. That was the original law, that government employees had no First Amendment rights. I have the roller coaster ride because it's been a bit of a roller coaster for government employees. First, they had no rights at all. Then the courts developed a standard that, well, as long as it's a matter of public concern, so that means if it's about private matters, probably not going to get First Amendment protection. And then we do a balancing test. What's the value of what the employee was saying versus what the reason why the government didn't want them to say it? But what I want to highlight for you guys is that there's a new requirement in a case called Garcetti, which was just decided a couple of years ago, where the court said whenever you have a government employee case, the very first question you ask is, were they speaking in the scope of their employment, as part of their job duties? If so, that's it, no First Amendment rights, because they're working for the government and the government is paying for them to talk. If the government doesn't like what they're saying while they're on the job, then the government can fire them. It may sound like, okay, that makes some sense, except perhaps when you start thinking about professors who are on the job and part of their job is to talk about things and teach your students and to write about things that might be controversial. And so the court in this opinion, I'll get to this in a minute, the court in this opinion did not address or did not resolve this issue. The dissent said, what about academic freedom? What about academic freedom? What about the professor who gets fired for saying something controversial in class or writing something controversial? Because that's part of his or her job, does that mean she has no First Amendment rights? So that, and the majority said, we'll get to that another time. The other problem was there's no protection for whistleblowers. There have been scores of cases coming out that are really disturbing where teachers have been reporting misconduct by other teachers or other disturbing things that they are required by law to report. And for whatever reason, if the principal or the university doesn't like what they're reporting, they can say, you're fired. And there's no First Amendment protection. The opinion the court issued says, well, you just have to rely on whistleblower laws, not the First Amendment. Okay. So there have been a lot of cases you probably have seen in the news about teachers and social media. Many of them are just where teachers are being really, really stupid, and I could talk more about that, but I just want to highlight one. This teacher here was suspended in Florida for making anti-gay marriage views known on Facebook. Again, the school realized when it consulted with the lawyers that this teacher had the right, when he was outside of his class, to express his view on a matter of public concern that was not affecting his teaching, and so he has since been reinstated. So a lot of interesting issues with teachers and social media. There have also been recent laws, Missouri and some other states have laws or considering laws to ban teachers from communicating with students on social media. And this is, again, as I was saying earlier, this, by the way, it's out of a concern that teachers are seducing their minor students, the students who are minors. So again, instead of just dealing with this problem of teachers seducing students, they decide social media is the problem. So no social media for you, without realizing the real benefits that social media can provide. Okay, so this is going to be the conclusion of my speech. I love the First Amendment. As you can tell, I'm perhaps a little bit of a lunatic on the First Amendment. But I also recognize that the most important principle of constitutional law is, does anyone know? The rule of 5. The rule of 5. This is that it takes 5 votes on the Supreme Court to get a majority. And those 5 votes determine what the First Amendment says. So I love the First Amendment. I love my view of the First Amendment. I love my view of the robust, messy marketplace of ideas. But not all of the justices are taking this view, particularly when we're talking about these institutions like schools and students and schools and government employees. They've issued decisions recently that are not favorable to First Amendment rights. And so the message here today, it's somewhat bittersweet, is that as much as we love the First Amendment, as much as we want to wrap ourselves around it, I want to have a blanket like that so I can just hold it cuddly all night long. The thing is that it's sometimes not enough. And instead what we need to think about are passing laws that can provide the protections that we want. So if we want to protect whistleblowing after that Garcetti case, and if we want to encourage government employees to come forward with misconduct and illegality that's going on in government, we need robust whistleblower laws, because it doesn't look like the First Amendment is necessarily going to give us that protection. If we want students to be able to talk online outside of school without worrying they're going to get punished for using a bad word, we might have to pass a law. And in fact, that's what Connecticut did after the Avery Doninger case. They passed a law protecting the students' speech rights. So I think that's where I want to conclude. We can love the First Amendment, but we have to recognize that it can't always give us everything that we want. It's been my pleasure to share my views with you tonight, and I look forward to taking your questions. Is there a question?
Who's first?
I think this has been addressed a bunch of times, but with the Twitter issue with the football team, sorry, I'm right here. Since they're a part of a team that they don't have to be a part of, how does that affect their First Amendment rights since they're choosing to be on the football team?
Right, so let me just say, this is a very unsettled area of the law. I just started looking into this issue about a month and a half ago because I wasn't aware that this was happening. And I thought I would just pull up the definitive law review article on this topic because I was not planning on writing one myself, which may be what I have to do. But so there are some people who take the view that participating in an extracurricular activity, whether it's student government in the Avery Doninger case or football or basketball on the university level, that participation in educational activities are a privilege. If you're going to take part in a team, then you don't have First Amendment rights at all. I think that goes a little too far. What I would say does make some sense, that if you're part of a team, you are going to lose some of your First Amendment rights, you know? So you're not going to have the complete freedom to say absolutely everything that you want about your team. Trash talking your coach, for example. You know, if you're going to report something that's well, I guess the coach here probably deserves some trash talking, but you know, if you're just generally griping about things, if you're attacking your teammates, you know, just complaining, you know, that can really undermine the morale in the team, and I do think that participation in team sports does require some unity of the team and some hierarchical control of the coach over the players. So I do think, you know, I'm not saying that you have an absolute to say everything, so in that way a team does limit your complete freedom. And, you know, I also recognize that there are times when student athletes are representing the school. So, for example, the NFL apparently bans its players from using social media during games. And I think that makes some sense in that, first of all, it's during a game, so what the heck are they tweeting during the game? And second of all, while they are playing, they are representing their team. And so what they say can really be imputed to the team. And I think that that can be the case, particularly with the high-profile athletes on football, basketball teams, that in some circumstances they are representing the school. So we do need to be concerned about that. But I would say it doesn't mean that every part of their lives they are representing the school. When they're on the field, they're representing the school, and so that might also amount to some curtailment of First Amendment rights. Someone else?
Thank you. I really applaud your views on counter-speech because that's something that I practiced when I was harassed by somebody recently. I just put up my own website with a picture of
Julia, can you hear that? No.
I can talk loudly.
He was praising my views. Oh, for counter speech.
Yeah, it's still in the microphone. No, you could just speak up.
Yes. So I had a website. He retaliated against me by sending hundreds of emails to the university complaining about me, and there was recently an article about me in the Tar Heel. But at length, the university's counsel asked me to remove a link to a link to a link that was on some external website, and I was just outraged by this, and I sent a letter to the chancellor saying, is there intelligent life in the office of the university council? And I also had an article published in the Durham Herald. They didn't like that heading, so they had the university council has too much time to spare, and the chancellor wrote me saying he was displeased with this. But at length, I did remove the link to the link to the link, but I asked the university council for an apology and a retraction of her statements. And shortly thereafter, the chancellor cut off my email privileges and also my website. And I'm wondering what your views are with regard to the First Amendment and retaliation for speech by a government official.
Right, well, I'm sorry I don't know all the details, and I wouldn't want to opine on your particular situation. I would say that what you're talking about would fit into a general theme that I've seen in my study of this area, that schools would like to make issues go away. So if they can just have you get rid of the link that's upsetting the someone who's writing the millions of letters, they would rather just do it that way than if they have to tolerate your speech, then they have to keep getting these crazy letters. And so they'd rather just make the problem go away. And so that's a common theme. You know, as far as retaliation, I think it's clear from my talk, I don't think retaliation is very good, particularly, I don't know where you were posting this link or in what context, but assuming it was part of your duties here, it's, you know,
Actually, I'm retired.
Okay, well, in any event, I do think that it is problematic. But that raises an interesting issue about academic freedom and who does it belong to? Does it belong to the university? Does it belong to the professors? What happens when the university wants one thing and the professor wants another? Whose claim to academic freedom trumps? So I just throw that out there as a little teaser.
I have a question. I sometimes have students who ask me about the university cutting off student email privileges for when they illegally download music, you know, that's the punishment, that they cut off their email access. How do you feel about that?
Yeah, well, I should have said that there seems to be a lot of authority for the schools to control their own computers and their own email systems. So they have terms of use, and if you violate them, then they're within their rights to withhold access. So I think generally, I'm not so out there. Generally, I do think that in the public school setting, if students are using school computers, there's greater authority of the schools to restrict what the students are doing on the computer. In the university setting, the same thing. You know, it depends on how far they're going, but if it's a matter of downloading illegal material or engaging in other illegal acts, I can understand the university's point of view.
Anybody else?
Dean,
Yeah.
do you recall off the top of your head the name of the Lollipops case?
Oh, Smith Green, I think. Smith-Green. I don't remember the full caption.
Second part of it, of some of these more recent, maybe not yet ripe cases that you mentioned, but some of the really fresh ones, do you see any cases heading to the Supreme Court? Are you watching for any, or is there a case in particular that you're looking forward to in the coming years?
Right. So the question, just to repeat it for those who may not have heard it, is the Supreme Court, do I expect the Supreme Court to weigh in on these issues? And I would say not quite yet. It's hard to say. I mean, when there's a new issue like this, the Supreme Court tends to like to wait for a little while and let things sort out in the lower courts. So it's only been very recently that we have more than one circuit court weighing in on the issue of when schools have the authority to punish students for speech that's outside of school, but accessible on computers in the school. And so we just had some decisions from multiple circuit courts, and I would expect the court to take a little bit more of a wait-and-see attitude, which is not a unique attitude for student speech rights. It's just their general approach to cases. They kind of wait to see how things are sorting out and weigh in after they can have the benefit of a lot of smart appellate judges weighing in on the issue.
Thank you very much.
Thank you.